What else would you like to argue about?
Yeah, I want to talk about toothbrushes and so on, and safe and secure,
Your Honor, I'd be happy
certified, confined. I mean, what do you want to talk about?
There are so many things, Your Honor. I was planning to address the CBP issues, but I'm...
The which issues, I'm sorry?
The Customs and Border Protection, which is CBP, that's the conditions in the CBP facilities.
Right.
Okay, but you're really going to stand up and tell us that being able to sleep isn't a question of safe and sanitary conditions?
Your Honor, I think what I'd like to stand up and
Not
say
really gonna say
is to focus the court on what the question is here in this appeal, and that is this is a consent decree, and it is focused on the language, the four corners of the language in the consent decree. And what I do want to note is that what the district court looked at was not asking the question, is there a violation of the language of the consent decree, and is this an overall violation of what the parties intended to prohibit in the consent decree? That's not. The district court instead looked at it from a different angle. The district court looked first, was there a violation of CBP's own TED standards?
Well, I'm not sure she did that first, and I'm not sure that the TED standard is really all that different from the more general statement or category or requirement of the agreement. Yes, the TED's standard is more detailed, but that sounds to me as it could quite easily come under the more general category of safe and secure.
Well, Your Honor,
Safe and sanitary, sorry.
and that's any number of things might fall under those categories, and I think
Yes, but sleep surely does, right? You can't be safe and sanitary or safe as a human being if you can't sleep.
Well,
and you said in your briefs it doesn't say anything about sleeping, so therefore there's nothing in here about being able to sleep.
I think the concern there is, Your Honor, the court finding that sleep, for example, is relevant to a finding of no safe and sanitary conditions is one thing, but the ultimate conclusion is safe and sanitary is a singular category in the agreement, and it was one has to assume left that way and not enumerated by the parties because either the parties couldn't reach agreement on how to enumerate that, or that it was left to the agencies to determine.
Or it was relatively obvious, and it's at least obvious enough so that if you're putting people into a crowded room to sleep on a concrete floor with an aluminum foil blanket on top of them, that doesn't comply with the agreement. I mean, it may be that they don't get super thread counts Egyptian linens, I get that, but the testimony that the district judge believed was, it's really cold. In fact, it gets colder when we complain about it being cold. We're supposed to sleep crowded with the lights on all night long, and all you do put us on is the concrete floor with an aluminum blanket. I mean, I understand at some outer boundary there may be some definitional difficulty, but no one would argue that this is secure and sanitary, safe and sanitary, or at least I don't think you're arguing that, are you?
Your Honor, I think what I'm arguing is that the way that the district court reached the conclusion was to say these specific items, and I think I will acknowledge I think sleep is the more difficult end of what I'm arguing.
We actually have an opinion that says that it's unconstitutional to make homeless people not sleep, right? So.
Correct, Your Honor, and I think, I mean, I do know, and I think that's part of our point, though, is that we're not talking about the constitutional standard here, and we're not talking about what CBP has implemented more broadly as its own TEDS policy. We're talking about... Are
you arguing seriously that you do not read the agreement as requiring you to do something other than what I've just described? Cold all night long, lights on all night long, sleep on the concrete, and you get an aluminum foil blanket. Are you saying that that's okay under the agreement?
And too crowded to lie down, which they also said.
I find that inconceivable that the government would say that that is safe and sanitary.
I think what I'm arguing, Your Honor, is that I don't believe that the district court made the finding in the way that Your Honor just detailed it.
Everything I just said comes right out of the district court order.
I think our concern is that the district court really looked at a condition, and again, as I said, I think sleep is clearly at sort of one end of her findings. I think we also look at...
Which is your strongest argument, then?
Well, I mean, I think what I would go to is when you start enumerating, for example, specific hygiene items, and the way that was done is that the court sort of enumerated these and say these fall under the rubric, these fall in the category of what could be required.
Again, it wasn't perfume soap, it was soap. It wasn't, you know, high-class milled soap, it was soap. And that sounds, no, that's part of safe and sanitary. Are you disagreeing with that?
What I'm disagreeing with is that the court ultimately concluded these things would fall under here, and then simply by not providing them, you have violated that tenet of the agreement. And I also would note that in that particular...
What do you... Granted that the decree, you know, doesn't have a list of items that has to be supplied in order to be sanitary. What's a reasonable, in your eyes, what's a reasonable definition of sanitary that the court could enforce?
Well, I think what I would ask is, what I would say is I would ask that the court find that the conditions were not safe and sanitary. What the court found is these things fall within that category, and by not providing them, that's an automatic breach of the agreement.
Well, I don't know if it's automatic, but to me it's more like, as Judge Fletcher says, it's within everybody's common understanding that, you know, if you don't have a toothbrush, if you don't have soap, if you don't have a blanket, it's not safe and sanitary. Well, wouldn't everybody agree to that? Do you agree to that?
Well, I think there's fair reason to find that those things may be part of safe and sanitary.
Maybe, are a part. What do you say maybe? You mean there are circumstances when a person doesn't need to have a toothbrush, toothpaste, and soap for days?
Well, I think in CBP custody, it's frequently intended to be much shorter term. So it may be that for a shorter term stay in CBP custody that some of those things may not be required.
Yeah, but I don't think that was the situation that the court was confronting. I mean, it wasn't as though those people were there for 12 hours and then moved on to the Hilton Hotel. No, they were there for a fairly sustained period, and at least according to the evidence that the judge believed, they weren't getting these things for a fairly sustained period.
Well, I do want to clarify that the judge did find that in Ursula, in one of the CBP facilities, that many of those things were present,
Right.
and that the evidence did show that that minors spent a much shorter period of time. There was only a small percentage of minors who weren't moved to Ursula very quickly.
So just to clarify, at some point in your brief, you appear to be saying that safe and sanitary has no independent meaning, and that the following, there's another sentence that follows it that has some details, and that's the only thing you're required to do. I don't understand you to be arguing that now. Is that correct? That's what your brief said, right? Your brief seemed to say that safe and sanitary had no independent meaning.
I don't think it has no independent meaning, and if that's the impression our argument gave, I apologize. I think that the position is more generally that to impose specific enumerated meanings that were not contained in the agreement, without in fact reaching the ultimate question of were the conditions overall in general, as a general matter, safe and sanitary, is not a correct finding of breach.
No, but you see, under that approach, if the district court were to conclude no, they were not sanitary, and all it could do is say fix it, they can tell you what to do, right? They can say you have to provide it soap. All they can do is issue an order saying make it sanitary, right? I mean that's what these details are there for. Isn't that the purpose, to give concrete meaning to the term?
I think.
I mean, you know, if CPB got an order saying, you know, we want your facilities to be sanitary, they say fine, we'll make them sanitary. But you know, I mean, who knows what sanitary is?
And I think that then goes to whether to what level the agreement could be enforceable.
That's partly what I'm getting. So you're saying maybe the agreement is so vague that it's unenforceable. That's almost your argument, isn't it?
To some extent, yes, Your Honor. I think that if the term in the agreement requires an after agreement interpretation by the district court, then yes, that does constitute a vague term that the parties didn't sufficiently clarify in reaching agreement.
You know, let's hear from the other side, and we've taken you 18 minutes and 52 seconds over time, but we will give you a chance to respond.
Thank you, Your Honor.